We are now live and recording.
Thank you, Sharon. Good afternoon, everyone, and welcome to the meeting of the Board of Trustees of the California State Bar. It is today, Thursday, July 3rd, a little after 12 noon. My name is Jose Cisneros. I'm the Vice Chair of the Board, and I would like to request Sharon if we could have a roll call.
Barahona,
Present.
Buenaventura,
I'm present.
Cisneros,
Here.
Good,
Here.
Gore, not present, Grande, not present, Harrison,
Present.
Huser,
Present.
Sowell,
Present.
Stallings, not present, Stevens,
Present.
Tony,
Present.
Trejo, not present. Vice Chair, you have a quorum.
Thank you very much. Next on the agenda is a call for public comment. Before we begin, I would like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or that are related to matters that are within the jurisdiction of this agency. Specifically, the Board of State Bar's governing body. This is the Board of State Bar's governing body and is responsible for exercising oversight of the State Bar. Additionally, we have a full agenda today. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. For those who are participating by Zoom, you should have a function for virtually raising your hand. It's a hand icon that should appear at the bottom center of your screen. If you wish to address the board, please click on the hand icon now, and State Bar staff will call on you in the order that hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key and then the number 9. Again, doing so will alert staff that you would like to make a comment, and staff will call on you to open your microphone so that you can address the board. For those of you who are participating from a noticed location, please alert the State Bar staff member present in the room that you would like to make a comment. And everyone, please note that staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash through the final 10 seconds to alert you. Before we open public comment, I would like to keep public comment to 1 hour, as we have only approximately 4 hours set aside for this meeting and several items to get through. If it becomes necessary, I will entertain a motion to suspend the rules to shorten the public comment to 1 hour. Should we just have that motion happen now?
Vice Chair, we're recommending waiting to do that until if we get close to the 1 hour mark, we can do it then. Based on this advanced signups, we're not sure that we'll need to do so.
I understand. Okay, great. So, Secretary Lim, can we? How many members of the public in total wish to make public comment?
I do see in total with advanced signups, raised hands, and looks like 1 in person, 18 altogether right now.
Okay, and also we want to please make sure that anybody in a remote location, if any of our trustee folks in a remote location, can please alert us if you have anyone with you that would like to make public comment.
Mr. Vice Chair, this is Arnie. I'm in Sacramento, and I do have 1 public commenter here at my location.
Thank you very much. Sharon, should we start with the person with Trustee Sowell, and then we'll go on to your list?
Yes, sounds good.
Thank you. Please go ahead.
Good afternoon, Chair and all trustees. My name is Kai On. Sacramento District Attorney and Attorney General did not investigate. Sacramento DA Office and Police Department provide me fake and forgery document for my father's death. They commit obstruction of justice. State Bar dismissed my complaint against Mr. Robert Bonter and Mr. T.N. Ho and claim it is a civil matter. State Bar case number 25-0-12611 and 12612. From February, I have been backing Board of Trustees to look into if any person interfered the operation inside State Bar of California. Someone is blocking me to find out who killed my father and is covering up a scandal about my father's death. I emailed the evidence to all the trustees before this meeting. Vice Chair, could you please provide information about my case?
We're just taking public comment at this time.
Okay, thank you. But please, all the boards of trustee, all trustee, could you please look into my document and help me to look into what happened inside State Bar of California, why they don't investigate Attorney General and Sacramento DA, they helping someone to covering up who killed my father and maybe covering up a scandal 25 years ago about the investigation of my father. Thank you.
Thank you.
Thank you.
Next.
So next we have Benjamin Cohn. Your mic has been enabled.
Thank you. Of the many testing accommodation related things that we had in dispute, I was very pleased over the last couple of years that remote testing was not going to be one of them, or so it seemed, and that the State Bar was making efforts to make that available and accessible again. Unfortunately, now the problem isn't necessarily directly the State Bar, but that Senator Umberg has chosen to make the supposed causes of the February exam all about remote testing. That was inaccurate. Measure screwed up in-person testing far worse and far more dangerously than they did remote testing. And the general proposition of remote testing had nothing to do with the reasons for February 2025 failing. Nonetheless, the legislature has included in SB 253 an expansion of the 2-year notice requirement for dropping the NCBE, even as the State Bar still remains obligated to pay Kaplan. And the NCBE is refusing to clarify whether or not they will allow remote testing as a testing accommodation, and not even if they are very clear that they do not allow it as a standard condition. The State Bar's FAQs have taken the position in the past, and even for July 2025 now, that the NCBE is not allowing remote testing as a testing accommodation. There's a little bit of evidence to the contrary in some public records of emails between Christina Dole and Sophia Martin, but the NCBE is refusing to confirm that. So in light of all of that, I urge you to take a position on this bill as it approaches the floor in opposition to try to get this requirement taken out so that you are not in a position where you might not be able to administer a bar exam because you're required not to use a different vendor and the NCBE is potentially insisting on unlawful terms. The applicants who need remote testing as an accommodation are not going to let this in-person mandate fly. This will be challenged, I have no doubt, at least by February 2026. And the denial or refusal to consider remote testing as an accommodation is enjoined, and you can't license the MBE because of this bill. And that might mean that you can't offer a bar exam unless you get emergency repeal. So I urge you to take a position in opposition to SB 253. Thank you.
Thank you for your comment. Next, we have Kamla. I do not see them in attendance. Next, we have Lily Sinclair. I do not see them in attendance. Next, we have Errol Killick. your mic has been enabled.
Hi there, can you hear me?
Yes.
Hi, thank you. Good afternoon, board members. My name is Errol Kulich, Legal Fellow for the Consumer Protection Policy Center, or CPPC, at the University of San Diego School of Law. CPPC is a nonprofit, nonpartisan academic and advocacy center and has examined California's regulatory agencies for over 40 years. On June 11th, the Supreme Court of California denied a request to explore proposals for admitting attorneys licensed in other states without requiring them to pass the California bar or attorney's exam. The court specified again that before such initiatives can be considered, statutory changes must be made to Business and Professions Code Section 6062. To assist the state bar in meaningfully addressing the court's position, CPPC has drafted legislation that would allow the state bar to pursue many of its longstanding and current objectives. Such changes to the relevant statutory provisions would provide enough maneuverability and authority to facilitate adoption of current and future proposals. CPPC has previously submitted our detailed memorandum and proposed legislation with the state bar for your consideration. The simplest way to amend the necessary legislative code would be within SB 253, the Annual Attorney Licensing Fee Bill. CPPC looks forward to discussing this approach with state bar staff at their earliest convenience. We also would kindly request a future agenda item to discuss this further. We are aware of the financial difficulties the state bar faces, as well as the concerns of applicants that seek an alternative pathway to licensure, We believe these goals can be achieved through these necessary legislative changes. We appreciate the State Bar and the Board of Trustees' consideration for this proposal. Thank you.
Thank you for your public comment. Next, we have Sylvia Argueta. Your mic has been enabled.
Thank you very much. I'm so sorry. The members of the Board of Trustees, thank you for your time. I am Silvia Argueta. I am the Executive Director of the Legal Aid Foundation of Los Angeles. LAFA has been providing free legal services to people living in poverty for over 95 years. I'm here to address business item number 3.3, the proposed amendment regarding changing the rules 9.41.1 related to registered military spouse attorneys for approval. The agenda items, at least what I was able to see, was that it would eliminate the 5-year limit, eliminate the additional year of MCLE, and a couple of other items, including removing the requirement to practice under supervision. LAFLA supports these changes. As we understand, they are required because to bring in the Civil Relief Act into compliance with federal law. However, I do believe that if public policy in support of service members' own public service now states that our state should expand our multi-jurisdictional practice and remove even the supervision requirement, this expansion should also apply to those individuals who come to our state for their own public service by working in legal aid. Our registered legal aid attorney program allows our legal aid community to recruit out-of-state attorneys to practice for a limited time under a similar rule, 9.45, as opposed to rule 9.41.1 addressed here today. I urge the Board of Trustees to extend a similar expansion to Rule 9.45. We believe that this is incredibly helpful for us in legal services. We currently have one of our registered legal aid attorneys. We just hired another one, and we have 2 others in the pipeline who have applied to work in legal aid. They will allow us to enable our clients to have more access to justice. And I strongly urge that you consider and direct staff to explore this other alternative. Thank you for your time.
Thank you for your comment. Next, we have Stephanie Miranda. Your mic has been enabled.
Muted. Hi, can you hear me okay?
Yes, we can.
Thank you so much. Good afternoon. I'm speaking on behalf of California Rural Legal Assistance, Inc. Thank you for the opportunity to speak on agenda item 3.3. In 2014, I passed the California bar, and that same year moved to Virginia when my husband, who was then a Navy fighter pilot, was relocated. I was among the first attorneys to waive into the Virginia bar as a military spouse. And it did have similar restrictions to what we have in California currently. While I'm grateful that this pathway existed, it came with very restrictive requirements. I had to secure a supervising attorney before applying, essentially needing a job offer 6 months before I could practice. I could not appear in court without that attorney physically present, and every letter, pleading, or document I drafted required their sign off. The only job I could find paid $10 an hour despite my California license and didn't offer any meaningful legal work or growth. Taking the Virginia bar also wasn't realistic since we were only stationed there very temporarily. Years later, when we returned to Virginia, I worked at a legal aid organization under similar rules. The supervision required by these rules isn't just oversight, it demands intensive hands-on micromanagement. Every task I completed required the time and attention of another attorney. In legal aid, where resources are already stretched very thin, this level of duplication means fewer clients get served. CRLA has seen firsthand how these challenges limit the services registered legal aid attorneys can provide. We rely on this program to recruit attorneys to rural legal deserts in California, but some restrictions in the current rules limit their ability to fully serve vulnerable communities. That's why I urge you to support the updates to Rule 9.41.1 and ask you to also review Rule 9.45, which imposes nearly identical burdens on registered legal aid attorneys. Thank you so much.
Thank you for your comment. We are done with the advanced sign-up, so I'll move on to the raised hands in the attendees list. We have Laura FM. Your mic has been enabled.
Hi there, can you hear me?
Yes, we can.
Okay, hi. Thank you to the board. Thank you for allowing this meeting to happen. This is a particularly new complaint I don't think the board has heard about. This is regarding a specific attorney, Kendrick Moxon, also known as Kendrick Litchie Moxon. He's an attorney for the the quote, Church of Scientology. He's the lead counsel for any sort of Scientology cases that have anything to do with the law. Why I'm bringing him up is currently that we've been protesting Scientology. I myself was a child born and raised in the cult, the slave organization of Scientology, and knew a lot of the internal abuses. And Kendrick Moxon was one of the lawyers and has been one of the lawyers defending and covering up multiple crimes, multiple evidence, multiple different lawsuits, all having to do with Church of Scientology. Kendrick Moxon is now putting protesters currently right now with the DA of Los Angeles using his fraud Scientology lawyer license to put protesters into jail for protesting. He currently has Scott Hochstetter in with the LADA for 6 felony hate crimes against Scientology. Kendrick Moxon has covered up and helped overthrow the IRS tax exempt status so that they could cover up crimes and not be seen. Kendrick Moxon was part of the cover up crimes of the Lisa McPherson case in Clearwater, her death. His own daughter killed herself in the internal organization, and he helped cover up the evidence, the letter that existed. Kendrick Moxon's license number from Burbank, California is number 128240. He is currently using his license to fraudulently put protesters, anti-Scientology protesters,
Thank you for your
in
public
jail.
comment. I'm sorry, but your time has
Please.
concluded.
Okay, thank you.
Next, we have Audit LA. Your mic has been enabled.
Hi, I'm going to continue on with what Laura FM said. J6 was a really bad, horrible event, but it looks like kindergarten play compared to Operation Snow White. Please look up Operation Snow White, where Kendrick Moxon is considered an unindicted co-conspirator. A bunch of people went to jail, including L. Ron Hubbard's wife, because they infiltrated the government to the highest levels to remove and to find anything against them, anything where they're named, so they can get rid of it. And then they also can blackmail, say, like the IRS to get their tax exempt status and all that stuff. You need to look into it. Why this man was able to continue practicing, even if he was unindicted, is unconscionable to me. I have a complaint against him. It was with you. It was dismissed for the moment because they said that the level of harassment isn't really at the point where the bar can get involved. They did leave it open for 90 days for more evidence. I am a protester, and I am being fair gamed. I am being followed. I've been having my neighbors harassed, all kinds of stuff happening. And none of that can happen without his approval. None of these, he's also defends and is the lawyer for people who come and attack. Okay, and Laura, she was attacked yesterday. And I guarantee if we find out who he is and he gets prosecuted, Moxon will be his attorney, because that's what he does. He is the attorney for Scientology for anyone that attacks Scientology protesters on behalf of Scientology, whether they're paying them or they're just doing it on their own. I don't know, but I believe that's a conflict of interest. He needs to be completely looked at, not just by the bar, but by the FBI, by any agent, law enforcement agency that there is. He is harassing me, through trying to CPRA me. He's trying to, they're trying to do articles about me, all kinds of things. So I'm tired of it. They think that like his.
Thank you for your public
Thank you.
comment, but your time has concluded.
Thank you.
Next, we have Ray Hayden. Your mic has been enabled.
Bingo bango. All right. So Ray Hayden here. I have something. We had that fee waiver for people who withdrew from February 2025 and has failed at 2025. The fee waiver thing. The fee waiver, from my understanding, is to be used in for July 25. I'm not. It's too close for that. But February 2026 or July 2026. But with the Umberg thing coming through, thank you. That it looks like you won't be able to have a remote exam, maybe possibly sort of kind of until beyond that. So what I'm asking for is California Bar to take the fee waiver and tag it to the applicant, not a date of the exam coming up, because I will not travel to California because the travel, not you guys, but the travel industry fleeces the flock. They know we're coming and they crank up the rates. And so I could do that, but why would I be an idiot? Because I'm probably going to, whatever, and fail again. So anyway, that's one thing: is attach the fee waiver to the applicant and not a time frame. I greatly appreciate that. I had something else. I agree with everything that Benjamin Cohen said, and the gentleman after him just nailed most of what I wanted to say. You guys know your financial status. It seems like Umberg didn't, because when he put in that thing, that bill, he could completely shanked the fact that if ExamSoft goes out overnight, you guys are stuck with no provider because you need a 2-year requirement. Now, I know Mr. Tony knows that's business. So in business, if your supplier leaves you, you got to scramble. And this bill has got big problems for not being able to cover that up and fix the problem. So there's got to be some wiggle room on that. One last thing. Good to see you, Ms. Wilson. And Jean, thank you very much. I appreciate your professionalism in my help with my things I was working on. Thank you very much. Have a great day.
Thank you for your public comment. Next, we have Jennifer Rodriguez. Your mic has been enabled.
Good afternoon, board members. Thank you for the opportunity to share public comment on business item 3.3. My name is Jennifer Rodriguez. I'm the executive director of the Youth Law Center, a nonprofit legal advocacy organization and a state bar funded support center that has worked for over 4 decades to protect the rights of children and youth in foster care and juvenile justice systems in California and nationwide. I'm here today to urge you to prioritize the expansion of the registered legal aid attorney program in addition to the registered military spouse attorney program. California is one of the most difficult states in the country to recruit and retain public interest attorneys. The exorbitant cost of living here, combined with a limited pool of lawyers dedicated to public service and legal aid, particularly those lawyers whose lived experience and background reflects the children and youth we serve, has created enormous barriers to building a diverse and skilled legal workforce. At the Youth Law Center, the RLAA program has been indispensable. It's allowed us to recruit exceptionally talented attorneys who bring the expertise, cultural understanding, and lived experience that our youth urgently need, especially now in a moment where children and young people are increasingly under attack by harmful policies and rhetoric. At least 2 of our RLAA attorneys will soon reach the 5-year limit imposed by current rules. Ending their ability to practice here would cut short the fierce advocacy they provide to some of the most vulnerable children in California. And in this crisis of access to justice, we cannot afford to lose them. If our state is willing to expand multi-jurisdictional practice for other forms of public service, we must extend the same commitment to legal aid attorneys who dedicate their entire careers to serving low-income communities. There's never been a more critical moment. I strongly urge the board to direct staff to develop a proposal to extend and improve the RLA program, invite public input, and move quickly to adopt reforms that will preserve and strengthen this essential pipeline of advocates. Thank you for your leadership and for considering this request.
Thank you for your public comment. Next, we have Sunny No. Your mic has been enabled.
Good afternoon, board members. My name is Sunny No, and I'm the Executive Director of Legal Aid of Sonoma County. For 20 years, our agency has provided comprehensive civil legal services to this county's most marginalized communities. I'm commenting also on Agenda Item 3.3 regarding the proposed amendments to the Registered Military Spouse Attorney Program. I strongly support these amendments, and I also ask that these changes be applied to the Registered Legal Aid Attorney Program. As reflected in the Justice Gap Study, Sonoma County has long had inadequate access to legal aid attorneys to meet our staffing needs and community needs. Despite the energy that I have expended on expanding our pipeline, this continues to be a significant challenge for us. I am also a career public interest attorney. Before moving to this organization, I practiced in New York City for 14 years in active litigation as a housing attorney and supervisor. Despite having passed the New York bar in my first attempt and over a decade of practice, I failed the California bar the first time I attempted to take it when I casually took it before I had a plan while on maternity leave with my first child. Everybody's dream for maternity leave. But when that changed during COVID and I decided to take a position at this organization, I did not qualify for the Registered Legal Aid Attorney Program because I had failed the bar. There's so much more to my story, but to be brief, before I was ultimately barred in California about a year after I moved here in my capacity at this organization, I was not able to practice and my role was limited to administrative and operational support. I cannot tell you how frustrating it was for me as a career legal aid attorney to not be able to serve clients and support our staff, including our very new attorneys, because of this barrier with the overwhelming community needs that came through our organization during this time. I firmly believe that more out-of-state attorneys would be interested in working here if these amendments are adopted. I know this from my own experience and my attempts to recruit interested prospective out-of-state attorneys with storied legal services careers who I know would increase the access to justice in our county and in our state. I ask that you please adopt these amendments to the Military Spouse Program and create a proposal for these same amendments for the Registered Legal Aid Program. Thank you.
Thank you for your public comment. Next, we have Jill. Jill, your mic has been enabled.
Hi, I'm here. I'm the third caller about Kendrick Moxon. It's highly disturbing that you have a person that is retaining their bar license when they use lawfare to go after the cult of Scientology's critics. This is a cult that has abused children, that has put babies as newborns in buildings that totally neglect them while their parents work 12 plus hours days in the C organization in the cult of Scientology. You allow things to go on like covering up for similar crimes that had happened in the Holocaust. This is a cult that has employed eugenics-like programs, devaluing disabled people. Also, they do what's called muster. He's part of an organization that makes people line up for roll call, like what was done in the Holocaust. This attorney is representing this. How do you allow attorneys to represent organizations that do the very thing that got judgment at Nuremberg going? This is a cult. One day you will see tribunals very much done like after the Holocaust. This is an organization that's employing very much tactics that were done during the atrocities in Auschwitz, Birkenau, Dachau, and etc. How do you allow where people are trying to protest and raise awareness for those atrocities? He is going after people that are going after those atrocities. Kendrick Moxon might as well have a sign on his hands that say Arbeit macht frei. That was the sign that was above Auschwitz. He might as well be holding that sign, and you might as well be helping him hold the sign if you don't do something about his bar license.
Thank you for your public comment, but your time has concluded. Next, we have Charlene Claish. Your mic has been enabled. Okay. Next, we have Zoom user. Your mic has been enabled.
Hi. Hello. Can you hear me?
Yes, we can.
Hi, my name is Rihanna Ghazi. I spoke last week as well. So I'm still waiting. The bar exam is in 3 weeks. My case is pending. There was an ADA violation. I have no clue what to do in my life. To be honest with you, I can't afford like my rent anymore. I'm waiting for you guys to tell me either to withdraw or where my case is going with a disability that I had. I have no idea what to do. I really need you guys to help me, please, or help students, give them the provisional license. We deserve retakers are the same exact people as the one that we drew. At least we had the experience of taking the bar exam like multiple times, 1 time, 2 times, and we got the experience. We studied for it. Now I do not know where I stand in my life. I am an educated person that's depressed. I cannot help the society. Right now, everybody needs help with immigration. I want to do volunteer work. Everybody's telling me you don't have license, you can't do anything, we can't hire you. We either have to hire you as a paralegal. So I really don't know what to do. Can you guys please, please, please expedite this? Can you guys please tell us what to do? The bar exam is in 3 weeks. I cannot put my life on hold for another 8 months to retake the February bar exam. I passed SAMPT. Is this really fair? Like, please give me a reason to have faith in this field. Please, I lost my faith. I don't believe in ethical work anymore. I don't believe that there's such a thing anymore. Please prove me that I'm wrong. I want to be wrong and I want to help the community. I want to help the society. I cannot afford my health insurance. I cannot afford my rent anymore. I cannot afford taking care of my dad who has Parkinson's disease. I need you guys to really help people. Please give us a provisional license or pass the ones that are over 1,300. Why is it my fault? Thank you.
Thank you for your comment. Next, we have M. Your mic has been enabled.
Hi, can you hear me?
Yes, we can.
Hi, I'm calling again on behalf of the victims of Scientology. I'm calling to talk about Kendrick Moxon. This man was involved in the largest domestic infiltration of the US government, the IRS, in the 70s to get their tax exempt status reinstated after it was taken away. And L. Ron Hubbard went on the run from the authorities. Then in the 90s, he was involved in a case of a woman who was killed at the Fort Harrison Hotel in Clearwater, Florida. So he's practicing in multiple states. There's Scientology locations literally all up and down California, quite literally, from very northern California to very southern California. They're going after immigrants. They're going after people who are coming here for a better life and people that are being targeted already by our own government. And they're holding them hostage. They're bringing them here on R1 visas and then holding them in the buildings, and not giving them their visas, and also not telling them or not allowing them to go home after their visas have expired. There's children in situations that they never should have been put in. And all of this is done with the knowledge of Kendrick Moxon, who is a licensed attorney in California. And as far as I'm concerned, attorneys should be, if they're not, and I'm not super up on the law, but they should be mandatory reporters. So he is definitely aware of multiple cases of child abuse, child neglect, sexual abuse, sexual assault, rape, all kinds of other things, and he has not reported those to the authorities because they're not allowed to in Scientology. So I personally would appreciate it if you guys would look into these things and personally look into Kendrick Moxon. Thank you for your time.
Thank you for your comment. Next, we have Elliot. Your mic has been enabled.
Hi, actually, this is Nora Ames, Nee Sova. I am calling in today. Thank you for this time. Also to speak about Kendrick Moxon, license number 128240 in the state of California. As people have mentioned before, he is an unindicted co-conspirator in Operation Snow White that took place in the 70s, where Scientology had infiltrated every single branch of government. I know that to be true because my father was also an unindicted co-conspirator in that operation, breaking into the California State Capitol by staying in the bathroom, the women's bathroom actually, waiting until the building had been locked down, and then went into the file room and stole the files. Kendrick is one of the people who, directed people on their statements on what to say and how not to get caught. My father was never indicted. He is now deceased. Additionally, he has been covering up a multitude of crimes that started under the leadership of Lafayette Ronald Hubbard, that started the multi-billion-dollar real estate scam, mind control, human child trafficking scam known colloquially as Scientology, and has continued and ramped up his illegal efforts in crime cover-ups under the leadership and stewardship of David Miscavige, who's the current leader of Scientology. But make no mistake, he is using the laws of the land to violate labor laws every day, as it was done to me while I was, entombed in the concentration camp there on L. Ron Hubbard Way in the blue buildings. They violate OSHA every single day. They violate child labor laws. They do bring people here on R1 visas who are children, who are adults, who are elderly. They hold those things hostage in their security offices under the direction of Kendrick and other legal advisors. Please investigate this man and disbar him. He is committing crimes against humanity. Thank you.
Thank you for your comment. Next, we have Henri. Your mic has been enabled.
Thank you. Yes, can you hear me?
Yes, we can.
Thank you. So I just want to follow up on many of the comments that folks have raised regarding not only just Kendrick Moxon, but other unindicted co-conspirators that collude with Scientology. And one of them is actually the city attorney in Los Angeles, Heidi Soto, who actually miserably failed to criminally prosecute me, just simply for the fact that I've been doing lots of reporting and documenting on the various criminal acts at the city level of Los Angeles and how they collude with Scientology in order to prosecute anybody that dares publicly criticize not only Scientology, but the city government officials that actually aid and abet all of these different criminal acts, such as issuing false permits to close down streets. One of the people involved in that is actually the director of the Bureau of Street Services of Los Angeles, Keith Mosey. And what happened in my criminal case is I've already written to the bar several times, and I know she's currently being investigated, is that Heidi did a political favor. I have her dead to rights on a public meeting where I recorded her, okay, where she actively admitted, knowing that my case was utterly frivolous, it should have never been prosecuted, but she did it anyway as a favor to Scientology. But it doesn't stop there, right? It doesn't stop there. Heidi isn't the only agent. There's many others. Right now, actually, I'm facing a bogus appeals case where a Scientology agent and attorney, okay, Stephen Tamer, who is the attorney for Anthony D'Amato, yet another Scientology agent that actively harasses. Actually, Nora Ames is one of the other victims that he's harassed repeatedly, making grotesque sexual remarks against in order to silence them and anybody else that dares publicly criticize Scientology, right? This is how this whole ring of conspiracy comes together. And in fact, when I reported Heidi to the FBI, you know what they told me? Okay, you know what they told me? They said, Henry, come back after you're finished with law school, and there very well might be a
Thank you for your
position with you
public
at the
comment,
FBI.
but your time has concluded. Lastly, we will go back to Charlene Claish. Your mic has been enabled.
Hello, can you hear me?
Yes, we can.
Thank you. Thank you for taking my comments. In my opinion, applicants who took the November 2024 experimental bar exam have not been treated fairly. When I participated in the experimental exam and experienced such horrible conditions that I was unable to take it on the day I was registered to take it, I had to take it the next day. Given the horrible glitches, I decided not to take the February 2025 bar exam. We were told that up to 40 points would be given to applicants who met an unknown threshold at that time. That threshold turned out to be 28 out of 49 questions, and if answered correctly. Later, it was determined that everyone who met the 28 correct questions would be given a full 40 extra credit points for the next bar exam that they took. I was working full time and I got 25 questions correct without studying for over 2 years for the bar exam. In my opinion, applicants who scored at least 15 correct questions should get 5 extra points. Those who scored 20 should get extra 10 points. Those who scored 25, an extra 15. I think it would compensate everyone that took the experimental exam in good faith, took time off work, and had to endure measures and competent administration of the exam. I think it would be fair, just, and reasonable. Those who used our common sense and sat out for the 2025 February bar exam, we've not received any compensation or consideration, even though we have suffered by postponing taking the exam. The second thing is I'm really astonished that they're hiring bar exam graders for the July 2025 bar exam, and the closing date on those applications was June 30th. I think that's absolutely absurd. Generally, historically, they've always had them as apprentices for at least one exam administration. I'm very concerned that they're hiring bar exam graders for the July 2025 bar exam who haven't been trained. It needs to be the same standards or similar as it has been for 30 plus years. Please look into that. Third, I work in family law currently. I've worked in mass torts and class actions, big law firms. I made over $50 million for the last law firm I worked for. I helped sign up over 5,000 new clients for the fires in Northern California, and all of those clients have been compensated. I know what I'm doing. I know I'm capable. I worked with Yale and
Thank you for
Harvard.
your public comment, but your time has concluded.
Thank you.
Vice Chair Cisneros, that concludes our raised hands for public comment today. I think you're on mute.
All right, thank you, Sharon. With that, we'll close public comment and we'll move on to our agenda for this meeting. The first item is a chair's report. We have a lot going on. I don't have anything to add there. So move on to the second item, the consent calendar. It's appropriate to ask whether any member wishes to pull any item or items off the consent calendar. Yes, Trustee Tony.
Yes, I wish to pull both items off the consent calendar.
Very good. With that, then we'll move on to item 2.1. This is the extended time to withdraw from the July 2025 bar exam and apply the fee waiver to a future bar exam. I believe Executive Director Leah Wilson will guide us through this item. Leah?
Yes, and I'm here today kind of in Donna's stead. She's out today, so I'm doing the admissions items today. Instead of presenting on the item, I was just hoping Trustee Tony to be available to respond to any questions that you have about it.
Give me a second, because I have to open it up. This is 2.1, correct?
Yes. This is the extension of the waiver of bar exam fees.
I would like to know what the intent of this is. I read it, but I don't quite understand it.
Okay, the intent is to allow those who are registered for the July 2025 bar exam to be able to withdraw but retain the free exam benefit through the 2026 exam administrations. Right now, the deadline to withdraw is or was June 2nd. And so anyone who withdrew after that date would presumably not retain the benefit for a 2026 exam because they didn't withdraw on time. We're requesting an extension in part, as you know, the Supreme Court only made its decision regarding provisional licensure on June 11th, which was subsequent to the withdrawal deadline. So some folks may have said, oh, now I'm eligible for provisional licensure. I'm not going to sit for the July 2025 exam. Under the terms of provisional licensure, I still have to take and pass a bar exam. So I'd rather give myself another year and take that free benefit and extend it into 2026. So it just gives folks more flexibility to use that free benefit.
And am I right that in reading this, that this is already been recommended by the Committee of Bar Examiners? They also recommend.
Yes.
Okay, so that's good to know. I'm just of the opinion that items that are not routine, this is not a routine item, extending, it shouldn't be on consent. So I support this item. And I certainly appreciate the explanation. I have no further questions.
Okay.
Okay, thank you. With that then, I'll ask for a motion in a second.
I'll move.
Second.
Great. Moved by trustee Good, seconded by trustee Harrison. Sharon, roll call vote, please.
Barahona,
Aye.
Buenaventura,
Aye.
Gore not present, Grande not present, Harrison,
Aye.
Huser,
Aye.
Soel,
Aye.
Stevens,
Aye.
Tony,
Aye.
Trejo not present, Stallings not present, Cisneros,
Aye.
with 8 ayes and 0 nays, the motion carries.
It's an aye for me. You didn't comment on me.
Apologies. Good,
Aye.
with 9 ayes and 0 nays, the motion carries.
Thank you. All right, with that, we'll move on to item 2.2, approval of technical correction to rules of the State Bar of California, Appendix A, schedule of charges and deadlines related to legal specialization fees. Ms. Wilson?
Yes, and I'd like to take the same approach unless trustee Tony just wanted an overview of the item, or did you have a specific question?
I would like an overview of this item. This seems like it's increasing, it's an increase of fees, is what I understand it to be, of legal specialization fees, and it doesn't feel like it's a technical correction. So that's why I would like a explanation of it.
Okay, so this is a correction of the schedule and charges of fees and deadlines to reflect a reversion back to the original fee schedule for legal specialization fees. Reduction limited term was implemented in 2021. So as the board may recall, you do have a reserve policy that sets a minimum reserve of 17% and a maximum reserve in most funds of 30%. The legal specialization fund, I don't remember at this time that it was well in excess, that fund balance of 30%. So the board decided, as a way of eating down that very high fund balance, to give folks not a fee holiday, but really significantly reduce the fees that would be charged for legal specialization exams in 2021. So the fee schedule was amended to reflect that fee reduction. Unfortunately, we did not come back as staff after that 1-year fee holiday and correct the schedule simply to revert back to the original fee level. We did not do that in the schedule of charges and fees. However, for the October 2023 exams, or the 2023 exams, we did charge the corrected amount, pre-reduction amount for those fees. We just hadn't corrected the posted schedule of charges and fees. So what this item does today is it corrects the schedule of charges and fees to reflect that reversion that should have happened after the 2021 temporary fee reduction. And it also applies the CPI adjustment to that corrected fee. That's the only increase that you might be seeing, is that we are applying the consumer price index adjustment pursuant to the board's policy to apply those adjustments annually. So it's simply a reversion on the schedule to the correct fees and application of the CPI index to those corrected fees.
If this were passed, when would it take into effect?
For the 2025 legal specialization exams, which I believe are going to occur in October.
I remember taking a vote on the on making a reduction. I don't have a memory of it being temporary at the time, or that it expired. What is the current, what do you call it? The reserve right now in this account?
Well, there's no longer a separate legal specialization fund. We consolidated that with the admissions fund. That's referred to in a different item. So the entire fund balance did support the admissions fund, was used to support the admissions fund. So there is no special legal specialization fund balance at this time. I'm just looking through the item that's hyperlinked here, the January 2021 item, to see. Unfortunately, it does not look like, and I don't know, Jean, if you can give this better eyeballs than me, that it was really clear that it was expected to be just a one-time adjustment. The resolution refers to the 2021 legal specialization exam fee schedules, not a permanent change to the fee schedules. I know it was not intended to be a permanent change, but I'm not quickly seeing that clearly in the 2021 item that's hyperlinked. So.
Right. Part of the challenge is whenever I convert these and save them to PDF, the hyperlinks go away. I don't know how to fix that.
Trustees, in case it's helpful, the staff report that Leah referenced does say that the Office of Admissions, along with the CBLS, has determined that it would be appropriate to reduce the legal specialization exam fees for the current year in order to spend down the reserve. So that does indicate that it was meant to be a temporary and not permanent reduction.
And I also, thanks to Cody pinging me, see the executive summary. This agenda item seeks Board of Trustees approval to lower the 2021 legal specialization exam fees applicable to the 2021 legal specialist exam only. So that does make it clear.
Okay, that's helpful. Thank you. That actually is helpful to me. Thank you. That's the kind of explanation I was looking for, that I didn't feel would happen during a consent item. So thank you for the further explanation. I am satisfied with it. Thank you.
Great, thank you. And I'm open to a motion in a second for item 2.2. And here we have a resolution.
Trustee Sowell, I'll make the motion.
Thank you. Second.
Trustee Stevens, second.
Great. First by Trustee Sowell, second by Trustee Stevens. Roll call vote.
Barahona,
Aye.
Buenaventura,
Aye.
Good,
Aye.
Gore not present, Grande not present, Harrison,
Aye.
Huser,
Aye.
Sowell,
Aye.
Stevens,
Aye.
Tony,
Aye.
Cisneros.
Aye.
With 9 ayes and 0 nays, the motion carries.
Thank you, Sharon. Next on the agenda is the discussion and preliminary review of Supreme Court proposed amendments to Title IX of the Rules of Court. I'd like to thank Executive Director Wilson and Deputy Executive Director Doherty for leading us through this item.
Great. Leah, I'll go ahead and kick us off if that works for you. Wonderful. All right, so I'm going to walk the board through what is a discussion only item on today's agenda. So to kind of set the stage, on May 28th, the Supreme Court issued proposed amendments to Title IX of the California Rules of Court, which are for the most part intended to clarify the responsibilities of the Committee of Bar Examiners, the board, and the Supreme Court with respect to the admissions process. Those rules were issued for a 45-day public comment period at the direction of the Supreme Court. They were issued by the State Bar, and that public comment period will end on July 14th. As of today, we have 25 public comments. This item today is, like I said, discussion only, and it's going to be to receive initial input on the proposed amendments while we continue to receive public comment on the rules for the next 11 days or so. And then following the public comment period, there's going to be a joint meeting between the board and CBE that is further informed by that comment to develop a joint recommendation on the proposed amendments. So a lot that we're hoping to accomplish as part of today's discussion, which includes familiarizing the trustees with the proposed amendments, which have been organized into a couple buckets for your consideration, get initial feedback regarding those amendments, and identify areas for staff to review and research. We'd also like to discuss other things that are relevant to these rules, including how the operations of CBE were modified based on the recommendations in 2017 in the Governance and Public Interest Task Force that the Board of Trustees approved, and pending legislation, including Senate Bill 253 and Assembly Bill 484. So I believe there are some slides that will hopefully be brought up. Great, thank you. And so we already talked about the goals. Sharon, I'm going to ask if you can actually go to the last slide with the timeline first, and then we'll kind of go back to the beginning. All right, so what I think would be helpful is to really just kind of tee up everything that needs to happen as relevant to the February 2028 bar exam based on the proposed Supreme Court rules, as well as the 2-year requirement notice of Senate Bill 253, which we'll dive into, and AB 484 as well. So very quickly, what may be required by Senate Bill 253 is a requirement to give 2 years notice to do anything that is different from what is happening at the July 2025 exam, meaning an in-person exam using the NCBE MBE questions. So that would require 2 years of notice, meaning that we would need to give that notice by February of 2026 to do one of two things. One of those things could be going to Next Gen, which, as you all know, is the only option from NCBE starting in February 2028. And then the other option would be essentially to do something else. So what we've laid out for you here is working backwards from the 2-year notice that's required to be given in February 2026, based on everything we're going to talk about. And I just wanted to start here. We will come back to this once we've shared more information about all of these different requirements, but I really wanted to kind of lay that timeline out. So this means that if we have to give 2 years notice for something by February 2026, there's going to need to be many other steps that happen beforehand. And I think that's really relevant to the issues we're going to tee up as it relates to the proposed rule amendments, as well as to get input from the trustees as to what you will want to see at the joint meeting of CBE and the board coming up in August here. All right, Sharon, thank you for that. If you could go ahead and go back to, I believe, slide 3. Great. Thank you. So, I believe back 1. Thanks. So as was teed up in the agenda materials for you today, we've categorized the proposed changes to the admission-related rules into a couple different buckets here. The first bucket is general oversight and admissions, and then we'll move on to 4 other buckets as well. What the rules look like as proposed is what we see as a narrowing of those state bar rules that require approval by the Supreme Court, meaning that there would no longer be Supreme Court approval required for testing accommodation rules, special admissions programs, conduct violations, and law school accreditation and regulation. So currently, those rules are recommended by CBE to the board, who in turn recommends those rules to the California Supreme Court. This would eliminate that last step for those rules in particular, but would still require Supreme Court approval of other state bar rules related to the bar exam, the first year law students exam, moral character, and any legal and pre-legal education requirements. So we wanted to tee this up as a question as to whether this is something that may be appropriate to go to the Supreme Court, or if there's anything within this bucket of items that may not go to the Supreme Court anymore that the board thinks should.
You're asking for comment, right?
I am asking for comment, yes, thank you.
Sharon, should we see if people have an interest in raising their hand and commenting?
And Sharon, in the room, we can't see anyone, so I don't know, it
Maybe
may
you have
work.
to go back away from the
Remove the slides
presentation.
for now, unfortunately, yeah.
Yeah, to get comment. Okay, does anybody have any comments this time? Trustee Soel?
I just have a question. Erica, can you explain notification and what the definition of sort of notification in this context means? Does notification imply that we can't do work in this area? Or does notification is it more defined by actually going the notion that we'll be implementing changes?
That's correct, Trustee Sewell. I believe it's the latter. Jean can correct me if I'm wrong, but it's the fact that we will be moving as of for a particular exam to a new format and new questions that the 2-year requirement is triggered by, not work to do that, to accomplish that in the future. So we could certainly, the State Bar could be working on developing movement to a different exam, and then for whatever date that is ultimately determined that is going to occur, you'd have to work backwards and give 2 years notice for that date.
Thank you.
I had a question.
Go ahead.
Another question, Erica, is suppose we give notice and then we don't like the work that's being done and we don't have confidence in what would be delivered in February 2028. Hopefully that wouldn't happen, but let's say it did. Could we withdraw our notice?
You would have to, so yes, however, the options become limited. So you would have to, there's not going to be an option for February 2028 to go to what we're currently doing, which is the
Right.
the MCQ.
Because of the next gen.
Because of next gen, exactly. So what would have to happen is there would need to be that 2-year notice requirement to either go to next gen or do something else. And that in between time, what's currently, at least to my mind, not clear in SB 253 is if you'd have to start that process all over again. I think currently you would.
Could we give notice in the alternative in February 2028? Say we want to do, our own bar exam, we want to have remote testing again, or in the alternative, we would do what we presently have, but it would be upgraded to the next gen multi-state exam. Could we do that?
That level of specificity to my mind is not within 253, but I don't think that's the intent that's there. But
Okay.
I see Leah with her hand raised.
say a couple of things. One, you're stuck to February and July if you stick with the national conference. One of the things that you get if you develop your own bar exam is you don't have to do it in February and July. Obviously, you need to give plenty of notice to test takers, law schools, and I'm not suggesting a radically different schedule, although one of the concerns that's been expressed for many years is why this exam is only given twice a year. So I say that to say, if you're going to go the route of your own exam, if you were not able to give that notice till April 2026, it's not a constitutional crisis because you could give your exam at a different time frame. So that's one thing I wanted to say. And then I don't think in the alternative noticing would work, although what constitutes that notice is not delineated. But we think it would require the scope of the exam to be noticed. And so I think it would be very difficult to tell folks, well, you have to prepare for this scope, next gen, or this scope, which is, you know, something else the state bar is going to develop. I don't know that that would pass muster.
Okay, I'm just to following up on Trustee Sowell's remark. I just want to make sure that we retain maximum flexibility and aren't, you know, backed into a corner with an option that isn't working out the way that we anticipated, right? So, okay, thank you.
Any other comments or questions?
So if not on this particular bucket, I think we can move to the next one, Sharon, if you don't mind. Which is moving forward to the oversight of development of the bar exam. So there are more things that the board is expected to have oversight on as it relates to the proposed amendments. And that includes the vendors that will be providing the questions, the standards for the administration or proctoring of the exam, the testing accommodation standards and grading process as well. So many things that the board currently isn't involved in and would arguably also require you know, more knowledge and expertise in than the board currently has. And so it would arguably eliminate some of the board's authority, or I'm sorry, CBE's, excuse me, authority in this area. So as you can see, I'd like to take this component of it in what's showing in column row 1, and then we can talk to row 2. And kind of get the board's input on whether you think this should be something that the board is more involved in than currently.
Trustee Harrison has a raised hand.
Please go ahead.
So I certainly do think the board should have involvement with these things. I'm particularly interested in being involved with these things, and so yeah, I'm certainly for that.
Thank you, Trustee. Sharon, anyone else?
I do not see any other raised hands.
Can I ask a question?
Sure.
If we take on this additional oversight, do we have the ability to hire consultants to advise us or to seek input from CBE on this stuff? Because I'm very uncomfortable with us reviewing this because none of us, you know, are bar exam statisticians or experts. I want to just make sure that we would be able to hire people and experts to appropriately advise us and or get recommendations from CBE as well.
So Trustee Good, I think you're keying up 2 issues here. One is that it would require taking on more staff, and frankly more staff regardless, right? This is another meeting that staff is preparing for to address these issues at the board level, as well as possible consultants and those things as you've mentioned. So that's I mean, frankly, it's staff either way. What you could see more of is these joint type meetings that are planned for August, where it could be accomplished at the same time as a way to perhaps create efficiencies However, I think you're still either way going to be looking at more staff time involved in this just because there are more people involved in the
Sure, and
process.
potentially, you know, third-party consultant
Exactly.
to make sure that we're getting it right. Yeah.
And I do see Trustee Buenaventura with the raised hand as well.
Please go ahead, trustee.
Thank you. There was a caller, a public comment that asked about the graders that are being hired to grade some of these exams. Could you talk about what the requirements are and what kind of training they actually do have?
Yeah, I'm going to ask Jean to jump in here if
I'm happy to. We do post all the qualifications on our website. Usually the case is that we solicit applications for bar exam graders. Those are vetted by staff, and then folks do typically serve at least one round of grading as an apprentice grader before actually grading the bar exam questions. I don't know how much detail you'd like, Member Buenaventura, about what the grading process is like, but typically there is calibration that occurs where panels of graders attend meetings and ensure that their grades are calibrated to one another so that applicants are receiving the same grade if any given grader was grading that portion of their exam. So that is done throughout the course of grading each bar exam.
And so Trustee Buenaventura, to address your question, what is proposed in these rules is currently, there's oversight of the grading process by the board currently through development of any changes to the state bar rules. But again, we're talking about more here. So right now it's rules that are implemented through policies and so forth that are developed at CBE and by staff. This would be something new from that. So it would be, in addition to any changes to state bar rules, also looking at standards that the board would be approving as well.
Okay, thank you.
Thank you. Sharon, anyone else?
Yes, Trustee Sowell.
Thank you, trustee Sowell.
Erica, I think I'm correct to presume that these are new tasks, correct? And with those new tasks, that those are additional costs. And how would those additional tasks be funded?
It would come out of the admissions fund. This would be an admissions function. So either to the consultants that would be hired as, through the contracting process, or if it was additional staff time within the office, or the need to bring on more staff that would be coming through the admissions fund, which, as we'll discuss in a little bit, is, already impacted.
Just want to caution a little bit. I'm not so sure thinking about this in terms of additional cost or staff time is that appropriate. I mean, it's right now the Committee of Bar Examiners is doing the things in the first box. Things are coming to the board with respect to these items in the first box, either as procurement items or rules. So that's already happening. This is expanding your responsibility versus things in that first row beyond just approving contracts and rules to look at things like standards and protocols. So the work is already happening. The work is already getting vetted right now in that first row by the Committee of Bar Examiners. So now it's additional work for you in terms of things that you'd be asked to approve, but I'm not so sure actually that it's additional staff work. And then to your point, Trustee Good, this has come up previously with respect to admissions in particular, whether or not the board would benefit from its own independent consultants. Right now, on the contracts item that we do have on this business agenda, you see two are being recommended for hire for exam development, exam administration. That's the kind of thing that could be expanded their scope to also support the Board of Trustees. That is built into this year's admissions budget, and it could be built in perpetuity. So I just want to caution, this is not like a whole new body of work that's not being done before in the first row. The second row is different. We are not doing cost benefit analyses, formal ones, the way that the rules contemplate. So I just thought that was important to clarify.
Thank you, Leah.
One more comment.
Yeah.
So thank you, Leah. That's really clear. I could see the board wanting to hire its own consultant to have kind of third-party objectivity to look at it, given where we are today. But in any event, I just wanted to add, irrespective of the cost or increasing responsibility, I'm completely supportive of Trustee Harrison's comment that we should be taking on this additional work in light of the current circumstances. So I'm very supportive of this.
Thank you, Trustee Sharon. Any other hands raised?
Yes,
All right,
Trustee Harrison.
Trustee
Yeah,
Harrison.
I just wanted to mention two things. I think most of the board knows I served on the Blue Ribbon Commission on the future of the California bar exam. And that work, in my opinion, wasn't complete. Like, we still obviously have residual issues that we're currently addressing right now on the future of the California bar exam. And the expectation from the legislature is that the Board of Trustees get involved with this. Senator Ashby at not the most recent committee hearing, which was in the Assembly, but the one prior to that, specifically called me out and said she wants me to be involved with this. And so there's a legislative expectation here, and there's my continued personal desire and commitment to address these issues. So yes, I would like these additional oversight tasks to be under the purview of the Board of Trustees.
Thank you, Trustee. Great conversation so far. Anyone else wanting to comment here?
Trustee Huser.
Please go ahead.
I wanted to just follow up on that issue of bar exam graders, because I think maybe the caller, and I know I've received something calling for more bar exam graders for this bar exam in 3 weeks. And then the minimum qualifications that I'm reading off of our website are admitted for not less than 1 year and then have passed on the first or second attempt. So pretty minimal qualifications. And so do we have graders and do we have proctors set up for the July bar exam that's coming up in a few weeks?
Yes, can say yes. And in terms of increasing the number of graders, this has come up a number of times. And I think Donna even reported to the board previously when this came up, there's a psychometric recommendation as to the maximum number of graders to retain consistency in grading. And we're using that number. And I can't remember what it is, but that is the number that we're using. And so that's a limitation on how many graders we can get, not the fact that we can't find graders. And in terms of proctors, yes, they've hit their target for proctors.
Anyone else? Sharon?
No more raised hands.
Should we continue?
Yes, so we can turn to the bottom row now. And so what this is within Rule 3.6B that would require the Supreme Court to approve any changes to the exam that require substantial modification to training or preparation required for passage, as well as proposing any changes to the administration of the exam as described in the previous section, not just those that require a substantial modification would require this cost benefit analysis. So this cost benefit analysis is really what is new here. And there are certain factors that have to happen anytime there are changes related to the exam that would need to be submitted.
I'm sorry, Erica, I can barely hear what you're saying.
Oh, I'm sorry. Apologies. So what I'm speaking to is the cost benefit analysis for any changes to the bar exam. This is something new that would be required to be done by the CBE. As you can see in the considerations, it's not totally clear if the board would weigh in on that cost benefit analysis, and if the Supreme Court would as well as what particular changes could trigger that cost benefit analysis. It says currently any changes to the administration of the exam described in the first subdivision of the rule, which are, there's a lot of different things that could require this cost benefit analysis. So that is something that will have implications for both the timeline and then slowing down the process and just performing the work as well.
Any comments or questions from trustees?
Trustee Tony has a raised hand.
Please go ahead.
Thank you. I don't have any concern with this. It doesn't, my interpretation of reading this is that there are areas in which the board is being asked to be more involved in some of the review process, that CBE be asked. And the way I look at the whole picture, it's really asking the board and CBE to engage in a closer partnership in general, in terms of shared responsibility for oversight to, help make sure we avoid the pitfalls that happened and led to the February exam fiasco. So I think these, both of what we've seen and the other parts make a lot of sense. And that the basic message is that the Supreme Court would like, as I read this, the State Bar and the CBE to have a closer partnership in making sure that there's accountability.
Thank you, Trustee Tony. And I guess as a follow-on to that, which I think is a good observation by Trustee Tony, will these same items and discussion happen in our joint meeting with the CBE?
Yes,
Thank you.
exactly. These are
That's
issues that were raised to CBE at their June 20th meeting in the same way that it's being done today to kind of tee these things up so people could think about them before that joint meeting.
Great.
One thing I'll just speak to really quickly as it relates to the cost benefit analysis. So this is, anytime there is a change to the administration, as within the proposed amendments to the rules of court. Separate from this, and we'll talk about it in a bit more detail in the discussion regarding the pending bills, but in AB 484 as well, there is this analysis that's required to evaluate whether adopting a uniform bar exam, including the NCBE uniform bar exam, would be more efficient and lower the cost of administration. So staff at this time, and that's a one-time requirement under AB 484. So in this initial exercise, it would likely be that something along the lines of the cost benefit analysis contemplated here would be done in conjunction with what's required by 484.
Can I just ask a question, Erica? Is it your understanding that right now the rule proposal requires that cost benefit analysis to go to the board?
It does not say where it goes. I think that we could certainly make that clearer in the rule, but there's nothing that says where it goes in the rules currently.
And the cost benefit analysis is what would trigger, say, a notice of transitioning to next gen or state bar developed exam or anything, right? The cost benefit analysis is a condition precedent for that.
Under two different authorities, correct. So under the rule here, under 9.6b, there would be this cost benefit analysis that would have to be done. Additionally, under SB 253, there would be that 2-year trigger if it's a change to the exam content largely, and then that 120-day trigger as it relates to any changes to the exam administration.
Okay. It's just my thought that the board, just given some of your comments about wanting to be more involved, this is the area that is the most high stakes, right? It's the decision to go to whole new vendors or whole new ways of testing administration. It seems to me this is one where the board would want to receive that cost benefit analysis. Just my 2 cents. And I as Erica pointed out, the rule does not suggest that that would come to you now.
Can I say something? I can't imagine that simply doing a cost benefit analysis is the same as making a decision as to what direction to go. Those are two separate discussions. And so I'm really not sure why there's an issue. The cost benefit analysis presumes no decision. It's just a cost benefit analysis.
I think that that's true. There's nothing else that I've read that would describe a separate process for making the decision. So I think because there isn't anything else that says how a decision would be made or approved, then this becomes sort of the vehicle for that, unless there's an alternative process or approach for decision making that you would want to recommend.
The state bar has to approve vendors, has to approve a budget, right? That's not a CBE authority.
Correct.
So yeah, that's why I think it's pretty clear that the state bar would still be involved and would have to, based upon a cost benefit analysis, make a judgment call. A cost benefit analysis does not decide anything. And what is likely is, what I would hope is that there would be more than one option on the table, and that we would see cost benefit analyses of more than one option. I think it's a challenge when there's only one option on the table and it's take it or leave it. I think it's of value to have more than one option on the table, so that we're not just looking at one, and it's good to have a cost benefit analysis of both of them or more, possibly. So, I mean, if we want to clarify it, fine, but that's my understanding of what my expectation would be.
It sounds like it's something that probably could use some explanation or clarification. Would this also be something we could discuss in the joint meeting with the CBE and perhaps include some extra language that would perhaps memorialize what Trustee Tony's describing, or if we come up with something else?
Yes, and I'll just add, I think this would be helpful for staff too at this joint meeting to hear what CBE and the board, assuming it goes to the board, wants to see in this cost benefit analysis too. So to Trustee Tony's point, that there's multiple options or alternatives considered, so that when they are being developed, they have everything that CBE and the board and perhaps the Supreme Court are looking for in making the decisions that are going to be required or already are required in the first call or the first rep.
Great. Sharon, any other comments?
No other raised hands.
Should we continue?
Yes, you can go quick to the next slide, Sharon, thank you.
Sorry, my computer is a bit slow right now. Yep.
So what is called out in the rules in this administrative and fiscal authority section that I'm going to turn to Leah to describe in kind of the history and context for is this is something that would go to CBE to be more involved in the admissions fund budgeting process, to review the fund's revenue and expenses and propose a budget for the Office of Admissions. So I'm going to let Leah describe how that role used to occur prior to the Governance and Public Interest Task Force report led to recommendations for changes in 2018. And Devin or Sharon, could you promote Justin as well while she tees this up? And you can take this down for now.
Okay, great. So I provided as an attachment a memo, which I apologize, it's referred to as a brief. Wasn't sure on what the format of this was going to be. Really, as I use this item as a vehicle for sharing this information, kind of getting it down into the record, something that's come up in many different conversations, like what exactly was taken away from the Committee of Bar Examiners. You guys have heard some, I think, comments to that effect over the many months. And certainly there's been an inference by some that the kind of fiscal crisis in the admissions fund is perhaps related to changes in the CBE's responsibilities vis-a-vis the fund. So what this attachment does is it outlines for you what actually happened with the 2017 Governance in the Public Interest Task Force with respect to the Committee of Bar Examiners, and specifically with respect to the issues that are relevant vis-a-vis these rule amendments. As you can see in the item, this is a multi-year effort that involved many different reports and studies, looking at the full array of functions under the purview of the Committee of Bar Examiners, including, for example, law school regulation, where very significant recommendations were made, but those are not addressed in this item. So specific to, I think what you need to know when you hear comments about things being taken away from the Committee of Bar Examiners' responsibilities, pursuant to the work of the 2017 Governance in the Public Interest Task Force and subsequent board action, 2 sort of administrative changes were made, with one with respect to moral character determination process and the other with respect to Chapter 6 violations, so violations of exam administration rules. Before the 2017 and the public interest, the task force work, the CBE essentially heard those matters in their first instance or the first impression. So if staff had a concern about something in a moral character application, that went directly to a committee of the Committee of Bar Examiners. Similarly, if anyone had received a notice of a violation during an exam, say for having a cell phone in an exam, and they wanted to appeal, that first level of appeal would have been the Committee of Bar Examiners. Fast forward to what it is today, those first levels of appeal, as I call them, are with staff, and then everybody has the opportunity to appeal to the Committee of Bar Examiners. So those are two changes. Third, with respect to budget oversight, what happened prior to 2017 was that the Committee of Bar Examiners received regular reports on the admissions fund budget from a member of their executive staff. We can't find any documentary evidence that suggests that the CBE was making budget recommendations to the board. What we can find is a recommendation that came through maybe to increase proctor rates, but not regular recommendations on the admissions fund budget, and no recommendations on a regular basis regarding fees assessed to applicants. So it was a receipt and review of reports that was happening. Also in this attachment, I want to show you what's happened with the admissions fund budget kind of pre-2017 to post, and give you at least some data points to consider when thinking about what's happened with the admissions fund budget. So one of the things that you can see is that revenue is very constant in the fund until we saw a pretty significant decline in the number of applicants. Nearly 80% of admissions fund revenue is generated by bar exam fees and moral character application fees. So when you see significant drops in the number of people pursuing moral character determination status, seeking licensure through the bar exam, you see very significant drops in revenue. And that's what we saw. At the same time, you had very sizable cost savings in exam administration due to the pandemic and the move to the remote bar exam. But when we returned to in-person examination after the pandemic, we found that the cost of in-person administration had escalated, and they continue to do so at a pace much faster clip than prior to the pandemic. So you had a dip in the number of test takers and moral character determination status seekers. You had increasing cost of the in-person examination. We also had a scenario where until the board established its policy to regularly review fees, first in 2017, and then more recently to review those fees every 3 years with intervening year CPI adjustments. And that was, I think, your initiative, Trustee Tony. Until then, there had been no process for regular review of fees that were assessed. So you see that many fees in the admissions fund had not been modified for many, many years. So you have a confluence of circumstances that led to the crisis in the fund. The crisis in the fund is a very depleting fund balance. Since the board kind of assumed full responsibility, or I would say since CBE stopped receiving regular reports on the budget, a couple of different things have happened. The board has stabilized the admissions fund through that regular fee setting policy and an adjustment of the fees. The board also stabilized the fund by doing something I mentioned earlier. You authorized the transfer of nearly $8 million in the legal specialization fund balance to the admissions fund in order to shore up the fund. So I see the sort of changes that have happened since the Governance and the Public Interest Task Force work as reflective of the board being actively engaged in stabilizing the fund and putting us in a position where even with all of the negative headwinds, we are still able to withstand. We are, even this year with these incredible additional costs, we are not going into the red this particular year. So there's a lot more in this memo. Happy to take questions, but really wanted to, again, provide this as some documentation of history as I transition out of the organization so that you all have it available to you. We have Justin Ewart here, with Deputy CFO, to answer any questions, and also what he's been also prepared to talk about is kind of his views on this proposed rule amendment, how it might impact our Office of Finance. But I'll just pause there, see if there are any questions or comments.
Any questions or comments? If not, we'll hear from Justin. Seeing none, Justin, you want to go ahead?
Sure. I'm just going to talk briefly about the impact of, maybe having to report to the CBE and the Board of Trustees. Our budget shop is 2 people. It's not a big shop. We're a lean shop. We've experienced the RIF this year. And so in my department, we've lost 1 person. It's not in budget, but we've lost 1 person. So we've declined in our capacity. And next year in the adopted budget, we're supposed to lose another 36 people throughout the organization after losing 40 people this year. This is to say that we have to be a lot leaner and we have to decide where we're focusing our resources. And if we had to report to multiple entities multiple times a year, that will have an impact on us because it's a duplicative effort. Every time we report to the Board of Trustees or the Committee of Bar Examiners, there's a lot of work that goes into it. There's a lot of planning and there's a lot of number crunching. We would also, when we pass the budget, as everybody on the board knows, it's a time-intensive thing, and we get up against the deadline, which is February 28th every year. If we had to report to CBE, there would be some logistics. We might have to have some joint meetings, or it might delay, presenting some of the things because we'd have to go back and forth and coordinate between the two. Not to say that it can't be done, but if we're being asked to be a leaner organization, these impacts do have a cost to them. But having 2, I will stop there.
Thank you, Justin. I'm not against having more joint meetings if that's what it would take. Any other comments, questions?
And the other thing I want to emphasize is that if we have 2 reporting authorities, having 2 people tell us what to do could be confusing for staff, because if the Board of Trustees and the Committee of Bar Examiners do not agree on policy, then it would make it more difficult for the finance staff to kind of implement that policy if there is disagreement between the 2 entities. So it's generally easier if there is one overall reporting requirement.
However, too, I think several people's points that could be through joint meetings. So the same thing, we're looking for consensus building, alignment, and so forth. It's just a very different structure than what currently exists with CBE and the board.
I'm not seeing any comments from anyone else.
Trustee Barrow.
Oh, I'm sorry, Trustee Barrow.
Yeah, can somebody and Leah, maybe you can speak to this. What's the advantage of having CBE have the authority here? It does seem like it's muddying the water, and we just heard from Justin in terms of feels like duplicative efforts. Am I reading that right?
Yeah, and I think it would be helpful. I know it's like a little difficult because of the conversation, but if we were looking at the rule amendment, I believe what it says is that CBE is going to make a recommendation to the board on the admissions fund budget. And I think that as that stands, it's workable. It's not unworkable. I think where you have challenges is what does that actually look like on the implementation side? I think what you hear about staff capacity, I don't think finance staff has the capacity to also staff a CBE finance committee that's meeting as frequently as the board finance committee and wants it to run all its own reports and analysis, right? And I also think that's where you start to get very confused about what the priorities are and who's on first, essentially. So figuring out a process for CBE to make an informed recommendation to the board at the right time that then feeds into the board's decision-making process on the budget, I think that will be critical. And I'm not sure what the benefit is other than more eyes on the admissions fund budget. And again, this perception that perhaps some of the challenges that we've recently have to do with the CBE's lack of oversight of the budget. But setting aside the merits of the proposition, I just think the implementation will be very important, and the timing with which these recommendations by CBE are made to feed into your process, and you are still making the final decision on the budget.
And there's two things in it. So it's for CBE to regularly review the revenue and expenses for admissions. So that is a workload there, the regular review. And then in addition to that, the proposal of the budget for admissions that goes to the board. So there's really two things that are set within that one, looking more broadly at the admissions fund requirement.
So this may be one where the board wants to give some comment or have some discussion with CBE again about what the expectations are for stopping that for CBE.
Anyone else who wants to comment? Anything else on this side?
Not on this one. There's one more bucket to discuss briefly, which is the governance and appointment procedures as relevant to current employees in the Office of Admissions. So Sharon, I don't know if you want to share that one last slide. Essentially, that while she's pulling it up, is what it would be is that CBE would be recommending to the board a candidate for director of the Office of Admissions. A few things to consider here. I'm going to start with bullet 2, which is that there has been a change in titles and organization within the Office of Admissions. So as you all know, Donna is the Chief of Admissions, and this refers to the director position. Mm-hmm. Additionally, there are multiple directors and assistant directors in the Office of Admissions. So that's another thing to consider as well as what's being contemplated here. Presumably the chief, and it's just a wording issue. So that's something. That being said, if this were to be retained, there's other things that should be considered as well, which is that this is not something that exists for other sub-entities at the state bar to have a role in the hiring process. Similarly, the board does not currently hire this position. It's limited to the executive director, general counsel, and chief trial counsel. And so this would be something expanding upon the board's current authority as it relates to this employee. Sharon, would you mind letting us know if you use a hand up?
There are no raised hands right now.
Thank you.
So I'm hearing the question that I think you're asking, which is, do we feel this changes in some ways too much? Do we are comfortable with adding another hiring process to the board, be under the board's approval?
Correct.
And as one question, and the other question is, if the idea is to involve the CBE in the hiring process. How do we exactly define that? Does that mean that the board can only look at candidate or candidates that come from the CBE, or they just can enter the mix, or what?
Yeah. And I think these are all questions, again, assuming that this is something that the board is supportive of, that you would want to consider jointly with CBE as what each group's expectations and roles should be.
Okay, but it might be useful to go into that joint meeting with some ideas of what we prefer, if we do have a.
If there is a preference, correct.
Right. So with that, again, any comments or thoughts from the trustees?
I do see 2 raised hands. Trustee Tony?
Please go ahead, Trustee Tony.
Thank you. This is one where one way we may be able to implement something like this would be, first of all, I am a believer in the executive director making this kind of hire, and of the board deferring to the executive director. We already have 3 employees reporting to the board. That is already an uncommonly large number. You know, between, right, the executive director, the chief trial counsel, and the general counsel. So I'm not eager to add another. I do think that the board can defer, but that the executive director could provide the top 2 to 3 candidates to CBE for review and recommendation. And that they could take that into account. But I still believe it ought to be, there's a way that we can get CBE involved, but also have the executive director retain the authority and judgment call.
Thank you. Sharon, any other commenters?
Yes, Trustee Huser?
I agree with what Trustee Tony just said.
And
Yeah, I want to agree also with Trustee Tony and Trustee User. You know, I do really think it's important to maintain a chain of command, and 3 people for the board to have directly reporting to is a lot, and I'm not eager to add a 4th. And this is something that should fall under the chain of command for the executive director.
Thank you, Trustee Harrison. Trustee Good?
I was just going to say exactly the same thing. I'm in complete agreement with Trustee Tony.
Thank you, trustees. Anyone else? I think we're in pretty violent agreement on this one. Where did this recommendation come from? The court or the
This is
legislature?
in the rules. This is in the proposed rules.
From the
The Supreme Court.
court. So it's a conversation we should have with the Supreme Court. It's representative.
Yes, so this would be something that the board seems to have direct input on as relates to.
And we should obviously share our thinking with the CBE when we have our joint conversation like that. Anyone else?
No other raised hands.
All right. Anything else on this item?
There's one more slide, and then going back to the timeline slide that we started with, which we may not need to, but related to the pending statutory changes. So as we kind of teed up in the beginning, I just want to make sure very clear what these have laid out for as possibilities come when these bills are signed. So just this 2-year notice to switch, well, not just, the 2-year notice to switch from NCDE to really any other vendor for multiple choice questions after this July exam. And then what was originally a 2-year requirement, but has now been reduced to a 4-month notice requirement before changing of functionality. As Donna would point out if she was here, it's not clear what changing functionality really means here and how far that goes. Meaning, for example, if there's a software patch that no one would actually see as a test taker, if that's something that is a change in functionality that would require a 4-month notice, you know, other configurations or abilities, if you're enhancing, you know, giving copy and paste, for example, if that's something that is being provided as arguably a benefit to the test taker, you know, giving 4-month notice for something like that, as well as obviously for taking away. So this is something where there's a little bit of ambiguity, at least at this time, as to what that notice requirement would be. Separate from SB 253, which is our fee bill, is this AB 484, which, as we talked about in regards to the Supreme Court proposed rule cost benefit analysis, is this one-time CBE report on whether adopting the UBE would be more efficient and would lower the cost for the state bar and for its examinees. So both of these bills are still active, and there are certainly cost implications associated with certainly 253, as has been messaged to this board and to CBE. Maintaining the existing July 2025 process of an in-person exam using the MBE is arguably the most expensive way to do the exam. And it really requires that we continue to do so for at least the next 2 years. There's a lot of unknowns past that point as it relates to what, assuming there's 2-year notice to move to next gen, what that exam is going to cost. We don't currently know that. We also, you know, we know what, let's say in 2 years you chose to go back to those Kaplan questions. We know the cost of that. That is a contract that is active with the state bar. And we know what the in-person costs are for administering an exam and as well. So that's just something that the board really needs to consider as it relates to this active bill. And I believe, is Justin still here, Sharon?
Yes, he is.
Justin, do you want to kind of talk about those implications a bit more?
The fiscal analysis?
Yeah, thank you.
Sure, I could talk about that. The chart included in the agenda item was originally presented to the Board of Trustees in late May, and it reflects projected deficit spending in 2026, which is a significant challenge for the admissions fund. While these figures are constantly evolving, I wanted to highlight a couple of key developments and considerations for the future. First, the bar exam pass rate was significantly higher than anticipated. This will positively impact the admissions fund revenue in that the number of candidates eligible for free retake has dropped substantially, eliminating a previous projected liability in the 2026 revenue. We expect to have final July numbers soon, which will enable a more accurate forecast in advance of the joint meeting in August. That said, based on our currently updated assumptions, the admissions fund is now projected with a modest positive balance at the end of 2026 of $900,000. However, this still reflects a $2.3 million operating deficit. In 2027, the deficit drops roughly to $500,000, so the ending fund balance would be $400,000. I want to caution against placing too much emphasis on these preliminary figures, and we'll have a clearer picture in August. That said, it's important to contextualize the fund balance. A $400,000 fund balance in 2027 would represent a reserve level of only 1.3%. By contrast, the board's reserve policy calls for a minimum reserve of 17%, or $5.8 million. To return to that target level, the fund would need to generate about $5.4 million. As noted in the agenda item, the board recently approved the increases to application fees, 26% for general applicants and 53% for attorney applicants. Maintaining this current ratio of $1,500 for attorney applicants and $850 for general applicants, we estimate reaching the required reserve target would require an increase of $550 or 37% for attorney applicants and $280 or 35% increase for general applicants. You may be wondering whether maintaining a 17% reserve is truly necessary. The reality is that the demands on the admissions fund are only expected to grow. For example, we are now projecting a $3.3 million deficit in 2025. When this board adopted the budget for 2025, we anticipated a 3.1 million surplus, largely based on the assumption of continued online exam administration. This just illustrates how quickly things can change and how critical the existing reserve has been in allowing the board to absorb these changes. Looking ahead, there are also potential costs related to the future administration of the bar exam that are not reflected in any of the current forecasts. These unknowns further underscore the importance of maintaining a strong reserve. And that's where I kind of highlight the admissions fund balance.
So just to kind of summarize, what's in your agenda materials was showing a by 2026 a negative reserve balance within the admissions fund. It looks slightly better right now based on these updated projections, moving that complete elimination of any reserve and deficit reserve now to 2027 possibly, or 2028 possibly. I think that's perhaps best case scenario that we're looking at, and there's just so many different factors at play that it could be worse than that, it could be better than that, but we'll have updated numbers in August to share with you and CBE at the joint meeting that will kind of lay this out with the implications with 253.
So right now, the bar has not taken a position on 253 or 484. 253 is our fee bill. And with respect to the fee, the legislation recommends a status quo fee level. And then it does include now these amendments that require the NCBE, NBE for the next 2 years. I think it would be very unusual for the board to not support a bill that includes the fee that we need to sustain the agency, but the board may want to consider providing formal comment from the chair, vice chair, the ledge liaisons on the bill, again, so that it's in the record, expressing the fact that this bill is locking the bar into the most expensive way of testing for the next 2 years. And that this, in conjunction with the existing contract with Kaplan, will likely mean that fees need to be raised again for applicants. So, that's something for the board to consider. You're not able to take a vote on that right now. But I do think it would be important to have that officially out on the record.
I do have a comment.
Yes, Trustee Good.
So I thank you to our executive director for that suggestion, which I wholeheartedly endorse. And this is indeed, sobering news, but not unexpected, right? In light of all the costs that we've been seeing. One issue I wanted to throw out there is everybody seems to be assuming that we might move to some sort of remote test taking 2 years, in 2028. And I mean, do we really think that's really realistic? Because as I sit here right now, I don't think that I would be comfortable with making a proposal in February 2026, not that many months from now, about going back and trying again what we just did, which was an absolute disaster. So I do think, some discussion of the financial implications should assume a longer time period than 2 years. Maybe 3 years is more realistic, but I think we shouldn't all be assuming that this is just a 2-year window. So I just wanted to put that out there. Thank you.
Thank you, Trustee. Any other trustee comments, questions?
Trustee Tony has a raised hand.
Please go ahead.
I just want to register my support to Trustee Good's comments about not rushing into a decision. I mean, we've yet to learn lessons from various investigations that are taking place or going to be taking place, both from the state bar and the state auditor, as to what went wrong. And I feel like we need to know that before we make a plan, to make sure that we don't replicate mistakes we've made before. Um, I would be cautious about using the budget as the prime factor for why we should make decisions, because I think that's part of what got us in trouble before. And so I know we're going to have some hard decisions to make when we get to budget. I would like to caution us against another large rate increase so quickly after the last one. I don't think we don't want to be in a position of test takers feeling like they're being punished for our mistakes with higher fees on top of very high increases recently. And I know that makes it difficult, but we've got some hard decisions to make. And the 17% minimum reserve, that's our policy. That's not a statute. We have, as a board, the ability to be flexible with that. And as we start thinking about this, and, I appreciate the fact that we're discussing today and not deciding today. I think that's a very good process to give us all a chance to be more thoughtful. Those are just some of the things I want to throw into the hopper.
Thank you, Trustee Tony. Any other trustees?
Trustee Sowell.
Please go ahead.
I just wanted to offer also my sort of endorsement of Leah's comments for us to get on the record as it relates to the state bar bill. I think it's important. Jose, you and I were at the hearing a week or so ago. Went by pretty fast with not a whole lot of commentary, and I do think it would be important for us to provide our best thinking as to the implications of the bill, as well as take a position on the measure as well. So I just wanted to offer those comments.
Thank you.
And Trustee Harrison.
Please go ahead.
I just have a few thoughts in my mind. I mean, the first is, we are currently under a contract with Kaplan, and this whole bill talks about switching from NCBE or another vendor. I mean, historically, in the recent history, we actually functionally did switch to Kaplan when we entered into an agreement with them. But I know for this next bar exam, we're going to go back to the NCBE's product because of the snafu. But that was just for this next bar exam. And so the bill to me is kind of confusing in the sense that it may assume that we're with NCBE right now, but in my opinion, we're with Kaplan right now. And as far as the long-term implications finance-wise for this bill, I do think that we should inform our legislative partners of that as well, because I think that is something to strongly consider how that will impact our fees, which is something that I believe that they want to reduce, or they want to reduce the burden on people who have graduated from law school and want to enter the profession by passing the exam. And so these are the thoughts that are in my mind right now. They're swirling around. One of the other thoughts that I have is that I think I lack information, right? I think I lack information on where Kaplan is in performing under the current contract we have with them, and in creating a bank of useful multiple choice questions for any future bar exam we intend to deliver. I want to know that before I get to the point of saying we should stay with Kaplan or go somewhere else or go with the NCBE. And so those are the thoughts that I have.
Thank you, Trustee.
Yeah, well, I think we should just clarify. I believe the bill explicitly says if you're going to change from the way you're doing the exam in July 2025. So it doesn't presume or allow for Kaplan as the baseline, Trustee Harrison. It's locking NCBE as the baseline by setting that July 2025 date. So I wanted to make that clear. In terms of Kaplan, they are performing under the contract, they're delivering questions, and we are continuing to work, do all the steps to content validate those questions.
And I think it'd be helpful to go to the next slide, Sharon, just as we're continuing even to have this conversation as it relates to the bills, because hearing that you may not be ready to go to a remote exam in 2 to 3 years. I think something that's maybe being missed here is that there's going to have to be some sort of action that does occur, whether it's to say it's a in-person administration with Kaplan questions, whether it's to say going to next gen, or whether it's to do something completely different from any of those things, which I don't think that the state bar is ready to do. But that's because of this requirement that the MCB will, I'm sorry, the MBE will no longer exist coming February 2028.
Okay.
And that we have to give either notice by February 2026, plus all of these other things behind or in front of that before doing so that would have to occur, including there's this October 2024 order of the Supreme Court to not go to next gen essentially, but to develop a new bar exam. So that's one thing that exists there. There are these requirements, if these rules are adopted, to do a cost benefit analysis of changing from the current administration to something different. So there are a lot of things that would require decision-making of some kind that is going to have to occur by February, and wanting CBE and the board to have enough information to feel like they are making a very educated decision in whatever changes they have to make by that February deadline.
Right, but just to clarify, to be absolutely clear, the point you have right up here in front of us, that the MBE goes away, and so we'll have to use something different than that. And it looks like our two current choices are next gen questions or Kaplan questions. That is completely independent on whether or not 2 years in 2028, we decide to do the remote type like we tried in February, or it's all in person the way we're going to do it for the next 2 years. So those are two separate questions and they can be answered independently of each other, I believe.
That's correct. However, there are still notice requirements to go to, so you can notice that you're going to do Kaplan questions in person, give 2 years notice of that, and then you would have to give notice again that you're changing to the remote administration.
Right.
Arguably, that's now a 120-day notice. You can correct me if I'm wrong there. But there still are notice requirements to make subsequent changes. Plus, there would be this cost benefit analysis that you would have to be doing as well to make that type of a change.
Got it.
And the next gen will not be offered remotely.
Correct.
So
Can I just make one more comment? So
Yes.
so now I appreciate what we're going back to your point about next gen is going to be the only option. I'm still really uncomfortable with making that decision by February 2026. To Trustee Tony's point, we're not going to have the results of the various investigations and audits that we're doing. We're not going to have the benefit of determining what operational changes maybe need to be made or anything else. And on top of that, there was a lot of criticism of the Kaplan questions throughout this debacle. And then on top of that, we have the Blue Ribbon Commission not recommending doing the next gen multi-state test. So, I mean, maybe, we're gonna be stuck with this 2-year notice requirement, but it would sure be nice if it was shorter so that we could have the luxury of more thoughtful analysis and more time on such frankly critical question as the multi-state exam. So.
And then I'll just add, sorry, I can't see who was speaking.
Trustee Tony has a raised hand.
Go ahead and finish your thought, please.
Okay, I would just say that, so if that's the case and the decision is to go to, because of the 2-year requirement to go to next gen, you'd have to notice that February 2026. Before that, there's arguably the need to address what was issued in that October order by the Supreme Court saying to go to a different exam. So
Yeah.
there is still, we still have to front load this pre-February to either ask the Supreme Court to allow for going to next gen, at least for now, while some of these questions are resolved, or to do something different.
Okay, Trustee Tony?
Yeah, I'm trying to see if I understand this. So just focusing on this next gen exam, they need a 2-year notice? Do they need a 2-year notice?
The statute requires, the existing statute, so not SB 253, but the existing statute requires a 2-year notice because it's a substantial modification. It's a new and different exam from what the California is currently offering.
Okay. So the administrators of the next gen don't have a 2-year requirement.
That's correct. It's the California statutory requirement.
Underneath this proposed bill. It doesn't exist now.
Underneath existing law. So this is something that already exists in the statute.
The 2-year notice.
Why is it in this bill then?
The 2-year notice that's in the bill is to do something different from the current status quo.
In the bill, the existing language is that anything that would require a change to the way that you prepare for the exam, among some other things. So one of the reasons you might recall why we felt we would not need to do that transitioning from the MBE to Kaplan is that Kaplan was being asked to develop MBE-like questions, and I probably shouldn't even say that because of all the copyright concerns without looking at any MBE questions, but the idea was we were not changing the way anybody needed to study for the exam. Fast forward to the conversation about next gen. Next gen is a holistic product. We will no longer be developing California essays and performance tests and getting just multiple choice questions from the national conference. You would be getting the entire exam for the national conference. Part of their motivation for developing this exam is to respond to years of criticism about their product. So it is intended to be a very different exam. So therefore, it will require a new way of preparing for the exam. And therefore, that notice requirement would have been triggered under the old statutory frame. What the new statutory language does is it prohibits us from going back to Kaplan, who ostensibly has been developing questions that would not require a new way of preparing for the exam. Now, the bar is precluded from doing even that without giving a 2-year notice.
Okay. So it seems that the new language is a clarification of intent. And that there was seems to me there was just a disagreement on what the intent was of the original 2 years, and this clarifies it. So, what is the difference in pricing between the current MBE and the next gen UBE?
My understanding is we don't know.
Yeah, the next gen is not the UBE, but the
It
next
says
gen.
next gen UBE. That's wrong.
Oh, sorry, I didn't see that. Yeah, it's not the same.
Confusing to me then.
So the national conference has not released pricing on next gen.
When do they plan to?
We do not know. I know that staff has asked. It's obviously going to be important in order to do a cost benefit analysis, for example. But if you just Google and try to go on their website and try to get pricing for the current products, which are the UBE and the MBE, that's not like readily, clearly available even now on the website. So I don't know how the pricing works for all states. I know what we've paid them for the MBE.
Okay. I'm glad we're having this discussion now, and I'm glad we don't have to decide now. Thank you.
Trustee Harrison?
Yes, a few thoughts. So I know this issue is currently being looked at in depth, investigated, in other words. But it's my understanding that the Kaplan specific questions that were delivered on the previous exam were not problematic. It was the ACS solutions questions that were the problem, because we needed to go out and get more questions. And so as far as the content of the Kaplan questions is, I don't really have any information to question their ability to produce good bar exam multiple choice questions. My issue is, are they going to give us enough that we can use them? And I know our executive director has given us today assurances that they are. And if long as that's the case, and this is leading me to my next point, it does assuage my concerns with switching to the next gen bar exam under the under the NCBE, because here's why. The costs associated with having to rent out large test taking centers so people can take an in-person exam, that's going to be a requirement with the next gen exam. It's going to have to be in person, to my knowledge. Also, I imagine a future where we're able to give more than 2 bar exams per year, maybe 3 or 4. So if a brand new baby, almost attorney doesn't pass the first one, they don't have to wait 6 months without earning a livable wage to take the exam again. Right? They can just turn around 3 months later, 4 months later, take another exam, maybe they pass it. And that's going to release a lot of pressure and concern for these recent law school graduates. And also the remote testing ability for people who have disabilities and need accommodations, and have other issues with the cost of having to take flights to certain places or live in a hotel for the exam because they're not located near one. There's fiscal concerns that I have for these test takers that could be assuaged by the ability to take a remote exam, which can be provided through some other provider other than the NCBE. And so these are the thoughts that are in my mind, and it's and that coupled with just, you know, machinations in the future of how we can offer an entirely different bar exam product that better reflects the practice of law in California, as opposed to being stuck with the next gen and being hamstrung with the 2-year notice requirement, which might potentially cause us to have to just stay with the devil we know instead of going with a better option. And so those are my concerns.
Thank you, Trustee Harrison. Anyone else?
There are no, oh, Trustee Barahona?
Yeah, I mean, I just wanted to build off of that, what Trustee Harrison mentioned, and also what Leah mentioned earlier in terms of taking a position. And I just wanted to kind of, it feels really important to not only take a position, but to really outline the deficit position we're like moving into in this new world, and really underscoring the reason we moved to sort of this remote testing option was for many of the reasons Trustee Harrison said before, but really sort of fits squarely in our intent to ensure diversity, equity, and inclusion, to ensure affordability, to increase accessibility to so many things that test takers have asked of us. And I do think that we will be, we should just underscore what feels to me, at least Justin, from what you mentioned, that we will need to tap those reserves. We will need to, and we will move into a deficit position unless we increase or mitigate those fees. And while I agree with Trustee Tony, I don't want to increase fees. We will have to, because we're making up for what 30 years of you know, fees that were not increased. And so I just think that we're getting I think we need to outlay all the challenges and difficulties with and be really clear about our position on those bills.
Thank you, trustee.
Trustee Tony?
I want to really highlight what both Trustee Berahona and Trustee Harrison said, is what they did is they gave a rationale for remote testing that did not did not prioritize the cost as the top priority. And I think that's the direction we need to do. We need to have clarity that we're doing things because it improves the experience of the test takers, because it improves our ability to assess somebody's capability to be a lawyer, qualifications to be an attorney, because it increases our ability to offer accommodations for test takers who require that. Okay. I think those are the things to talk about and lead with when we submit a letter of support with amendments. Okay. Asking for flexibility. That is where I think, our strength is, not leading with because our budget is broke, because we messed up. Okay. It's because we're going to fix things and we have a bigger vision for what is more fair for test takers, what is more accessible for test takers, what is better for the public in terms of assessing their ability to understand and apply California, law. Those things I think are the leads and are the strong points. I really encourage that when we do it, we lead with that.
And I'll just very briefly say, if it's okay, those are many of the things that all of you have said are what the guiding principles that you worked on, I believe, at the May meeting were, right? So it wasn't about the budget, it was about all of these other things as reasons to do something, or to lead your decision to do something, be it Kaplan or anything else.
Good point. Any other trustees?
No other raised hands.
Great. I think we had a very healthy conversation. Any other points that were intended to be raised?
That was largely it. So what I will say is that, this topic of the timeline that you're seeing here will be a topic at the joint meeting as well. And so to the extent that there's been a lot of points that have been raised as part of this conversation as things that the board certainly would like to see as it relates to this decision at the joint meeting. But if there's anything else that the board thinks is relevant to those conversations, that they want to provide staff with now, that would be helpful. Otherwise, we can continue to have those conversations at a one-on-one level to present back.
All right. All right, unless we hear from anyone else, we'll move on then. Next is item 3.2, approval of specified contracts pursuant to Business and Professions Code, section 6008.6, and we are joined.
Trustee Ferris, may I ask for a 5-minute break?
Why don't we have a 5-minute bio break suggestion, Trustee Tony? We'll see everybody back in 5 minutes.
Thank you.
see. Okay, I think we're trying to bring people back. If people could come on screen if they're available, so we can see if we could get going. Looks like we have nearly everybody. Okay, let me try again. Our next item is item 3.2 on the agenda, approval of specified contracts pursuant to Business and Professions Code, section 6008.6. And we are continue to be joined by Finance Director Justin Ewart. Justin, take it away.
Hi, thanks everybody. This is kind of a standard item where contracts above 50,000 for regular contracts or above 100,000 for IT related contracts come to the board for approval. I'm happy to answer any questions or tap Donna's stand-in, Leah, if it's admissions related, to answer any questions.
I'll go quickly through the first couple that are admissions related. The Humro contract amendment, you'll recall at the last board meeting, you approved a contract amount for this vendor who is going to conduct the scoring review and the testing accommodations review for unsuccessful February bar exam test takers. There was a request by Trustee Tony in particular and some other board members that we try to accelerate the testing accommodations portion of that review. We were able to work with the vendor to do that. So this amendment reflects the additional costs associated with accelerating or compressing the TA portion of the review in particular. I do want to note that although the scoring review, a portion of their work will be fully completed prior to the July bar exam and in time to notice people that, you know, hey, you passed the exam, you don't need to sit for the July bar exam after all. We can't guarantee that for the accommodated applicants just because of the need to go through thousands of hours of video. So while it's been accelerated, the process is not going to be fully complete prior to the July bar exam for those accommodated applicants. So that's the first contract. I'll just pause there and see if there are any questions.
I have a question on this.
Go ahead.
Yeah.
So and maybe I'm misreading it, but it says that Humro quoted 196 and change to meet the desired accelerated testing accommodations review timeline. So why does the staff want an additional 40,000 above that? I that's the part I don't quite understand.
It's just to give us a little bit of flexibility. So the 196,378, for example, doesn't include all costs. There's some expenses that are outside of that contract amount. We don't know what they would be, incidental expenses, but we don't know what they are. If something comes up in the course of the engagement, we want to ask them to do a little something more with respect to, I don't know, a number of applicants, maybe ask them to re-interview a couple of applicants. It just gives us some flexibility so that we wouldn't, or you all wouldn't have to convene the contracts committee again to do amendments. So that's why, just to afford that flexibility.
Thank you.
Thank you. Any other trustees' comments or questions? Any other comments on this side?
So let me go quickly to the next two. I mentioned this in the previous discussion. This item seeks approval or spending authority vis-a-vis two consultants for admissions functions, exam development, exam administration. What they'll be working on is laid out in the item. I do think that in addition to what you see here, we do have it mentioned, there's still looming in the background that October 2024 order that we develop a brand new bar exam. Several of you have spoken to that point. And once there is real clarity, which needs to come soon, about what the path forward is that the state bar wants to pursue, assuming that you still would want to develop a new bar exam, these folks are very uniquely skilled and able to support in that effort. And in fact, when this funding, $250,000, was originally included in the 2025 admissions budget, it was for consultants to work on the brand new bar exam. we haven't been able to get that off the ground. And so we're kind of repurposing these funds at that time.
So this is just contingency. If they do the work, then we'll pay them that. Yes? No.
Well, this for the work that's outlined in the in their current SOW, it's to do work now to help with the cost benefit analyses that need to be done, the research that the Committee of Bar Examiners is going to ask to be done, to create a real rubric for the question development. So one of the lessons learned is that we were developing hundreds of multiple choice questions for the first time on our own without a real transparent rubric and framework for doing so. That will be developed by these folks. So doing work right now on the pressing needs, and should that initiative begin on the new bar exam, they would transition to working on that as well.
Thank you.
And if you can see Trustee Huser has her hand up. Go ahead.
Yeah, I just had a question. If we have 2 years before we have to, get approval to do anything, how can we do a contract now to create a new bar exam? I'm not sure how those two requirements would work together and whether we'd have authority to even do this. So I'm hesitant to approve a contract before we know whether we even have authority to even consider such a thing, but maybe I'm misunderstanding.
So I think what they'll be asked to do in the first instance is not related to the new bar exam at all. It's related to the circumstance we find ourselves in today. We have not had fully articulated and publicly transparent procedures for making decisions about how the exam is going to be administered and how the content will be developed. Recall that even if we use the MBE questions, we've been developing our own essay and performance tests for years. And some of the criticisms that came up, for example, lack of copy editing, that was a fact with respect to our own essays and performance tests and has been the case for years. So we need to shore up our existing processes. That's what they're going to do. There has been some turnover and departures in admissions. And so these folks are plugging in on very present needs that are in the Office of Admissions. In addition, should the work go forward on developing a new bar exam, which the court did order that last October, the initial phases would include, as contemplated by the CBE, and then what was coming to you, but has never come to you for approval, is a new steering committee to develop the new bar exam. That steering committee would need to be staffed and supported. So if the decision is made to go forward, these individuals could transition to supporting that. But in the meantime, there's plenty of work for them to do to help us with what we're doing right now.
I personally just think there's too much uncertainty as to what we're going to be allowed to do, who's going to be allowed to do it, who's going to make decisions, that I don't think we should get into any more contracts that are binding on us that we're going to have to pay for until that's resolved. Maybe that gets resolved in August in a joint meeting with the CBE. I don't know, but I personally do not feel comfortable hiring anybody to do anything given the current state.
Okay, I understand that. I would just say we have lost the director of exam administration, and we've never had somebody dedicated purely over exam development. And so I think just to keep the work going that's currently going while we're trying to backfill various positions, we do need additional support. And we also currently have a contract with Kaplan. We are currently receiving multiple choice questions. It would be, I think, unwise for the bar to just let them sit on a shelf and not perfect the questions. And so a very transparent and holistic process for perfecting those questions, which we haven't had heretofore, would be valuable. So I think these are consultants. This is hourly rate contracts. So this is not money that we would pay regardless of the work we ask them to do. So just wanted to provide that bit of context.
Even if we all sat here and agreed with every word you just said, which I think I do, we don't have authorization if this bill passes. And so that's the problem. And so I'm very hesitant in light of unless somebody can speak to our Supreme Court liaisons, the CBE, get everybody in agreement, I'm just very hesitant. We keep doing these things where we try to change things, and then we're told, nope, stop, you can't do anything for 2 years. And now we're saying, well, we need a consultant to help us go forward. So I'm just a little hesitant. I agree with what you're saying, but I didn't make the bill that said we couldn't do anything for 2 years either.
Yes, Trustee Harrison.
Yes, I can represent that. I've spoken to our Supreme Court liaison, and he's interested in us moving beyond what the constraints of the NCBE and creating a different type of bar exam. And I know that's not an official communication from the Supreme Court, but this is what I think the Supreme Court has expressed in other ways, and even the legislature once as well. This bill came to me as a surprise because it does create an impediment from us moving beyond the NCB if we want to do that. And I don't know what type of special interest groups are behind that or not, but that's just what I have to say about that.
Okay, and I think I'm apologizing if I've confused things, because if you see in the item, there's a lot of stuff these folks will be asked to do that has nothing to do with the new bar exam. And then at the end, it says, lastly, the consultants will be engaged to advance any work initiated in response to the order to create a new bar exam. But everything above that is not related to a new bar exam. It's not dependent on transitioning to Kaplan questions. It's really saying we need more infrastructure support in the Office of Admissions. That's one of the lessons learned from what happened. We need professionalization. We need really transparent and publicly available rubrics and frameworks for how decisions are made. And so that's really in the first instance what they'll be asked to do, as well as make recommendations on what is your real staffing structure need to look like in the Office of Admissions for the critical exam development and exam administration functions, even if we keep doing in-person MBE for the next 2 years, there have to be ways to do it better than we've been doing it. So again, I may have muddied the waters, but it's not all about, developing the new bar exam.
So this contract's basically a guardrail so we don't step on another landmine?
Yes.
Okay.
But if you look at the description, the middle of the paragraph, with regard to exam development, we're going to do this, that, and the other. So it's throughout, it is exam development, whether it's existing exam or later. I'm just expressing my just very negative thoughts about that 2-year period where we're supposed to be, hamstrung to do anything. But so I agree with you, but we do have that bill pending. So I'm not the person to talk to the Supreme Court liaison, but somebody surely is, and make sure they're okay with this. So I just think under that bill, I would interpret this as saying we're not entitled to enter into this contract.
But again, under that bill, correct, but we're under the order from the Supreme Court. We are supposed to be working on a new bar exam. And this would, amongst all the other things you said, Leah, also begin, or if needed, start work on that?
Right, but right now we are developing our own essay and PTs. We always have been. So right now we're engaged in exam development. Right now, our current process could really benefit from some professional independent consultant advice. As I gave an example of, we never copy edited our own questions that we were drafting, let alone these new multiple choice questions. I don't know how many other things we aren't doing with respect to those questions that we've been developing for years, that these consultants may come in and say, this is a better way to do it. This is a better way to choose folks for content validation. This is a better, that's what we're asking is for our current process. Nothing there, to me, there is no implication or no relationship between the 2-year ban and what these folks will be doing. The period. Then there is the question of, will the board at some point choose to begin working on an entirely new bar exam per the October 2024 order? I can share that in the discussions that I had with the Supreme Court liaison, the conversations that I understood took place with the Committee of Bar Examiners, that's been described as a 5-year effort. That's nothing that could get off the ground in 2 years, just to be clear, like an entirely new bar exam. So I guess I want to caution that these consultants are not being brought on board to develop a new bar exam.
Thank you. Anyone else?
Yeah, a quick comment. I support entering into the contract.
Thank you, Trustee Harrison. Any other discussion?
I think, Erica, there's another contracts item that you were gonna cover maybe briefly, and then the last two we were not going to, or the last few we weren't gonna speak to. I'm not sure.
That's correct. So
Okay.
the last one that we wanted to cover is the contract amount for $136,000 to enter into a contract with Harbor Government Solutions. We have previously engaged this organization, and what we're asking for here is for them to develop an RFP for us to obtain a new vendor for case management systems. So for those of you who don't know, there are several offices that don't have a case management system at all and are doing a lot of manual work and a lot of manual file management to effectuate their work, including our Office of our CSF, our Lawyer Assistant, our Client Security Fund, our Lawyer Assistance Program, and our Mandatory Fee Arbitration Program. Separate and apart from that, our OGC and OCTC are using what have been described to us as very out-of-date systems. ProLaw being utilized by OGC is something that's so dated that many that we've heard OGC staff do not use it and are using workarounds. And then Odyssey requires a lot of staff resources in the Office of Chief Trial Counsel to do manual work and do workarounds and so forth, as well as within our IT office to deal with updates and configurations and so forth. So all of this to say, I think the reason we're calling this to your attention is because it's not necessarily this RFP that we're teeing up for you, but in the future, there's going to be a further request for the actual CMS itself. So this is a request to utilize a vendor to prepare the RFP to have a stronger, better CSF or CMS for the entire state bar to more effectively do its job.
Thank you. Any comments or questions? Yes, sir. Trustee Tony.
I very much support case management systems and efficient ones. I wish there was a way we could see a cost benefit analysis on this. And I don't know if that's if that will be part of the proposal development process, but it would, because this seems to be one where, this is the tip of the iceberg, the 136, right? That's just, that's the search firm for fee, for identifying the vendor for the case management system software and operations of it. And just would wish there was a way that we had a bigger picture, and maybe they'll do this as part of it. But I'm just letting you know what I would love to see at some point. Something that says, here's what we're spending now on case management. Here's all the human resources going into it. Here are all the inefficiencies. Here's where it creates bottlenecks. And I'd love to see something that says, having a new integrated CMS system is going to save this much more time. It'll remove this bottleneck. And hopefully it will help reduce the attorney discipline backlog, which is really what I want to see. So anyway, I'm just throwing that out. It's more of a comment. It's not anything that anyone needs to do anything about right now.
Great thought, though. Thank you, Trustee Tony. Anyone else? Anything else on their side?
No, I'll just say we have some of that information, so we can follow up on that as well.
Okay,
I think that's everything for this.
that's
item.
everything. So we're ready for a motion and a second if we so feel.
I'm happy to move.
I'll second.
Thank you. Motion by trustee Good, second by trustee Harrison. Resolve is in front of us. Roll call vote, please.
Barahona,
Aye.
Buenaventura,
Aye.
Good,
Aye.
Gore not present, Grande not present, Harrison,
Aye.
Huser,
Aye.
Sowell,
Aye.
Stevens,
Aye.
Tony,
Aye.
Trejo not present, Stallings not present, Cisneros.
Aye.
With 9 ayes and 0 nays, the motion carries.
Thank you very much. Next on the agenda is proposed amendments to California Rules of Court, Rule 9.41.1, related to registered military spouse attorney program. Presented by Brady Dewar. Have we promoted Brady?
Yes.
Great. I'm not seeing him here. Oh, there we go.
There we go.
You're on mute.
You're on mute, Brady.
Good afternoon, everyone. Took a minute there to get promoted.
Thank you very much for joining us. Please go ahead.
Of course. Well, this item requests approval for the State Bar to send to the California Supreme Court proposed changes to California Rule of Court 9.41.1 governing the current registered military spouse attorney program. These proposed changes were approved by the Committee of Bar Examiners at its June 20th meeting. The changes are all necessary to align the rule with recent amendments to the Federal Service Members Civil Relief Act, which in effect requires states to provide full reciprocity in attorney admissions for service members and their spouses who relocate to a state due to military orders. As such, the proposed changes streamline the process for becoming what is now called a registered service member spouse attorney, expands the program to include service members as well as their spouses or their registered domestic partners or those in civil unions with service members, and removes the requirement that program participants practice only under attorney supervision. Once in the program, however, such service members and their spouses or registered domestic partners or those in civil unions with them can be subject to all obligations of regular state bar licensees, including MCLE, submission to state bar discipline, payment of annual fees, and fingerprinting, and the proposed rule provides for all of that, thus serving public protection. Because the new rules, once adopted, will supersede the existing state bar rules concerning the RMSA program, this item requests that those rules be repealed upon approval by the Supreme Court of an amended California Rule of Court 9.41.1. Finally, I wanted to thank two of the newest members of our Office of General Counsel team, Jen Sperling and Joel Kim. They did much of the work to analyze the federal law and develop this rule very quickly. I hope that you'll all get to meet them at a meeting soon. And with that, I will open it up for any of your questions or comments.
Thank you, Brady. Questions or comments from trustees? If not, we're open to a motion in a second. Trustee Sowell, please go ahead.
Just a quick question. I mean, I'm in support of this item, but we did hear a bunch of public comment around, I think it was section 9.45, which was the legal assistance I guess for corresponding sort of rule in this particular regard. And Brady, if we wanted to pursue some sort of reciprocity or something similar as was suggested by a number of the public commentators, how is that something that should be amended into this motion, or is that something that we can do separately?
Well, two things. So I think that we should not, because of Bagley-Keene, take any formal action by adding a resolution directing anything on something other than this 9.41.1. And I also note that those rules, any change there would have to go through a little bit of a longer process. This change is exempted from the requirement for sending out for the formal 60-day public comment period because it is necessary to comply with federal law, to conform to federal law, excuse me. So with those two caveats, I think the proper way forward would be for the chair or vice chair in agendizing something for the next meeting to discuss that with staff and move it forward that way.
Yeah, I would be supportive of that, and I think there would probably be other trustees I would hope that also would be supportive of that, given what it is that we heard in public comment. So thank you for that clarification.
Thank you, Trustee Soel.
And I'd also note, of course, that it might be obvious that now that this program is going forward on an expedited basis, that could inform those discussions, the experience here.
Okay.
Great. Any other trustees? Then a motion and a second.
I'll make them.
Yeah. Second.
Trustee Harris, motion by Trustee Harrison, second by Trustee Tony. Thank you very much. Sharon, roll call vote, please.
Barahona,
Aye.
Buenaventura,
Aye.
Good,
Aye.
Gore not present, Grande not present, Harrison,
Aye.
Huser,
Aye.
Soel,
Aye.
Stevens,
Aye.
Tony,
Aye.
Trejo not present, Stallings not present, Cisneros.
Aye.
With 9 ayes and 0 nays, the motion carries.
Great. The board will now move to closed session pursuant to Government Code Section 11126C17 to discuss an approval of the 2026 to 2028 Memoranda of Understanding, Attorney Unit and General Unit between the Service Employees International Union Local 1000 and the State Bar of California. Sharon, you will assist us in getting everybody into closed session?
Yes, the link was just sent.
Great, everyone, if you could switch over to the link, and then remind you to everybody that after that, we'll be switching back to the open Zoom. Thank you. See you there. Sharon, are we back? Do we have to record?
Yes, we are recording and live.
Great. Thank you. Hello, everyone. We're coming back out of closed session and we have a reportable action on the closed section item 1.1. I'm pleased to report that the Board of Trustees has approved the terms of the new MOUs between the State Bar and the Employees Union SEI Local 1000 for the 3-year period beginning January 1, 2026. We'd like to thank the union for its cooperation in an efficient and respectful negotiation process. Our employees are our most important asset in fulfilling the bar's public protection mission, and we believe that the new contract is fair to staff and supports organizational stability. With that, we are pleased with this action and decision and pleased that we have a new contract. And that concludes our agenda for today. And with that, we'll close this meeting. Thank you, everyone. See you next time.